My name is Councillor Spencer Farmer. I've been nominated as the chair for this subcommittee hearing. A few administrative points to start with. Fire evacuation procedure. I'm told that there are no planned fire drills. So if the fire alarm sounds during this meeting, please leave the building at once by the nearest available exit. Escape routes are indicated by arrows on the green signs. Not use the lifts. If anyone present has difficulty in negotiating the stairs, please make yourself known to the committee services officer, who will escort you to the most appropriate staircase for evacuation. When clear of the building, proceed directly to the assembly point on the Views meadow. I can't get my orientation, but the Views, where a roll call will be taken. Not re-enter the building until told to do so by the officer in charge. Person chairing the meeting, on hearing the alarm bell, will interrupt proceedings and announce, "I am suspending the meeting," and repeat the above instructions. So thank you very much on that one, on fire evacuation. The other one is, I'm sure you're all aware, but the meeting is being recorded and live streamed. So anyone who wishes to remain in the meeting is accepting of the fact that they are being recorded. And if anyone isn't, then yeah, okay, fine. Thank you very much. I shall now introduce the panel members. As I said, I'm Councillor Spencer Farmer. I actually represent Hartley Witney Ward.
I'm Councillor Chris Axon and I represent Crookham East Ward in Church Crookham.
Hi, I'm Councillor Alex Drage and I represent Yateley West.
So first of all, can everyone else introduce themselves, please? I think we'll go around the room and take a little bit of time because we'll have to try and remember names. There's quite a few people here today.
I'm Roger Stanwell, one of the directors of the Odium Community Interest Company.
I'm Michael Drayton. It's the same, a director of the Community Interest Company.
Helen Tyler, also director of Odium Community Interest Company. I'm also councillor on Odium Parish Council. I'm not here representing Odium Parish Council today, only to make the statement that we do have full support of Odium Parish Council.
Hi, Andrew Wakeham, Senior Licensing Officer from the Shared Licence Service.
Hi, I'm Deborah Lazenby. I'm Licensing Officer, Case Officer for the Shared Licensing Service.
Hi, I'm Carrie Lavers and I'm a resident of Odium and live in the Bury.
Was that Lavers?
Sorry,
Lavers, yes.
Didn't catch your name again.
Carrie.
Carrie.
Hi, I'm Louise Dunn. I am a member of the community. I live in the Bury and I own the Bury house and the stable flat.
Thank you.
Hello, I'm Nancy Stewart Bruges. I, with my husband James, to my left, we own Webb House, which adjoins the pub and has a flying freehold over the entrance to the pub. And we have residents in 4 flats therein.
Stewart Bruges. In terms of my fellow members, do either of you, I have no interest to declare. Do either of you have any interest to declare?
No, none at all.
No, none at all.
And again, formal question. Are there any objections by any party at this subcommittee hearing who has objections to any of the members on this panel? That's helpful. Some other administration, just to advise that all representations and procedural questions should go through the chair. If we need to direct elsewhere, for example, our legal representative, we will do. Generally, no evidence may be submitted for the first time at the hearing, but I understand we've been shown a document which has a photograph on it. And I believe all parties happy for that to be submitted. You have a copy. We don't have a copy, but I have seen it, but thank you. Sorry, yes, sorry. I do apologise. 2 other people.
So Kathy Long, I'm from Community Services, taking the minutes today.
Good afternoon. I'm Tola Otudeko, the legal representative. I will be advising the committee on the law and procedure in this hearing, but I will not take part in the decision-making process. Thank you.
Thank you. Carrying on, evidence must focus on the promotion of the 4 licensing objectives, and the subcommittee will make a decision after hearing representations. Formally, a decision notice has to be issued within 5 working days. Dependent on how this hearing goes, we may or may not advise that we're going to come back with an interim statement, but I think we'll take advice as the meeting goes. And the hearing is conducted in public, except where exempt information about applicant is disclosed or members that consider the matter after hearing representations, but I've had no such representation, so this meeting is in public. Question for the legal officer. Checking that the applicant has displayed and published notices as required in relevant Licensing Act applications. Okay. And the hearing procedure is to hear the application and other representations, allow parties to clarify evidence. What we'll actually do is we'll go to the lead officer, then we'll go to the applicant, we'll go to the representations, and there'll be an opportunity to ask questions of clarification, etc. And we have, and I'm assuming everyone has read the written representations and has the paperwork in front of them. Excellent. Rather long-winded, but there's a few people here, in which case I hand over to the... We have people in the public gallery, and we have 4 people sat here, obviously, who are making representations. Are you all here speaking in your own right, or will there be a spokesperson for the majority of this? I'm happy either way. I just want to understand how you wish to operate.
So I am speaking on behalf of the residents who met together and we submitted a joint representation. But I think there were Carrie, did you submit your own representation?
Yeah, so I submitted my representation when it initially came out, but I didn't get a response. So I just wanted to add my point of view, basically.
Okay, that's fine. Understood. Thank you. In which case, we'll move to the lead officer to start proceedings. Thank you.
Today's hearing is to determine a premise licence variation application for the Bell at the Bury in Odium. Excuse me. Application details are shown within the report and the appendices. Bell currently holds a premises licence authorising alcohol sales between 1100 and 22:30 Sundays to Tuesdays, 1100 to 2300 Wednesdays to Saturdays, contrary to paragraph 2.2 in the report. I think it was put down as 1200 to start. That was incorrect, Chair, and it is 1100. The licence authorises alcohol for the sale to be consumed on the premises itself and within the external rear courtyard. Use of the rear courtyard is time limited and subject to conditions. This variation application proposes to include off sales, which would allow customers to consume alcohol outside of the premises plan. Pub intend to place tables and chairs for customer use in an area adjacent to the frontage of the Bell. To do this, they need to obtain a separate tables and chairs permit. I will elaborate on this shortly. Officers are satisfied the premises licence variation application was served and advertised in accordance with the regulations. Within this statutory 28-day consultation period, 9 representations were received from residents and the Council's Environmental Health Officer. See Appendix 3. The proposed limiting off sales and conditions to impose should the application be granted. The case officer attempted mediation between the applicants and parties making representations. The residents asked for the off sales to cease by 2100. The applicant offered to reduce off sales to 2200, and no agreement was reached at this time. When determining premises licence variations, it is pertinent members focus on the proposed variation only. The residents' representations include parking, traffic and smoke-related concerns. These matters fall outside the scope of the Licensing Act 2003 and they do not relate to licensable activities, nor are they within the applicant's control accordingly. They cannot be taken into account in today's determination. The area the operator proposes to place tables and chairs is referred to within representations. The applicant did apply to Hart District Council for a pavement licence, which was consulted about simultaneously to the variation application. However, the Bell planned to leave their furniture in place outside rather than remove daily. Pavement licences apply to removable furniture only. This means the applicant is required to submit a fresh, separate tables and chairs permit application. This would be subject to stakeholder and local consultation, which conditions could be imposed in relation to, such as usage times, layout, and signage within that area. This licence variation application does not propose to include additional external area to their premises plan. Members are therefore determining the proposal to add off sales to their existing licence. Matters referring to setting limits or placing signage specifically in the tables and chairs area need to be considered as part of the tables and chairs application. For example, and without prejudice, members could not impose a condition requiring signage to be placed in an area outside of the premises plan. They could impose conditions about displaying signage within the premises and noise management measures within the direct vicinity of the premises. Please note, off sales also relate to the ability for customers to purchase drinks to consume in other places away from the premises or at home. In carrying out its duties under the LA 2003, the licensing authority must focus on licensing matters only and the steps it considers that are appropriate to promote the licensing objectives. Members can only determine matters relating to the proposed changes and within the control of the licence holder. As well as promoting the objectives, the Licensing Act has other key aims and purposes for everybody involved in licensing work. These are listed within the Section 182 guidance at para 1.5 attached to Appendix 6. And they include protecting the public and local residents from crime, antisocial behaviour and noise nuisance caused by irresponsible licensed premises. Giving the police and licensing authorities the powers they need to effectively manage and police the nighttime economy and take action against those premises that are causing problems. Recognising the important role which licensed premises play in our local communities. By minimising the regulatory burden on businesses, encouraging innovation and supporting responsible premises. Encouraging greater community involvement in licensing decisions and giving local residents the opportunity to have their say regarding the decisions that may affect them. When determining the application, the subcommittee must consider the evidence of all parties at today's hearing and have regard to the Council's licensing policy and guidance issued under Section 182 of the Licensing Act, and take steps they consider appropriate to promote the licensing objectives. The options available to the committee are contained under Section 35 of the Act and shown within the report. Members must produce a decision notice detailing reasons behind their determination of the application and include appeal rights. Although very long-winded, I hope this sets out the application and we are happy to answer any questions the subcommittee may have.
Thank you very much. Before I go around to applicants and respondents and then to other members, I just have one question of clarification. I think you said, and thank you for just correcting the times in the summary note. I think you said that the the licence hours that were approved at the last hearing from Wednesday through Saturday were 11 till 11. Was that correct? Monday through Tuesday, was it 10:30, and then Wednesday through Saturday, 11 till 11?
Yes.
Okay.
Yes.
I notice that if I'm looking at page 12 of these papers, on Wednesday and Thursday, we've got an 11 o'clock start time for licensing hours, but Wednesday and Thursday seems to be reduced to 10:30 from 11 o'clock. Is that correct? Just checking that is correct. Thank you. Wanted to check that point. Does the applicant or representative of the applicant have any questions for the officer? Respondents have any questions for the officer?
There was one small point, which was, as I understood it, the pub were proposing a 10:15 finish time for service rather than 10, but it's just a minor point in their response to our representations. So we're a little bit further apart because we were proposing 9, as is the environmental health officer.
Noted. I know that was brought up as part of the mediation discussions, although agreement appears not to have been reached. I was going to clarify what they were requesting on timing when we got to that part of the proceedings, and I'm sure that can be discussed at that point. Any questions from yourselves? Chris?
No, none at all. Thank you very much. Very comprehensive.
Yeah, great sum up. Thank you.
I just have one question for the officers as well. We obviously approved, and there was a decision notice from the original licence application in November. And there was a lot of discussion at that subcommittee hearing, and there were some terms and conditions, some additional licensing conditions that were opposed over and above, for example, the courtyard and other factors. To your knowledge, have there been any deviations from those licence conditions or substantiated complaints about activity at the Bell since then?
No, Chair, we've not received any complaints. As far as we know, everything has run smoothly since that time.
Okay, thank you very much. In which case, I have no further questions. I will move over to the applicants to say what they wish to say.
Thanks. I'm going to start, if that's okay, just to give you some context. I'm not sure to what extent you guys know the history of Odium Community Interest Company and how we've come to apply for this application variation. And then Mike will go into some of the specifics. So we stand here representing an Odium Community Interest Company, which was formed in 2022 with the sole objective of purchasing, repairing, renovating and reopening the Bell pub. Now, the Bell pub has stood in Odium in the Bury since 1509, or was licensed in 1509, and has been a long-standing part at the centre of the community. It stands in the Bury, which has previously been a market square and is a public open space. It's within the conservation area in Odium and is a protected Grade 2 listed asset and of heritage significance. The pub itself was closed during lockdown and was sold to some developers, and we've been through quite some tortuous process in engaging via both planning committee and planning appeal hearing to sort of object to the development of that property into houses. So there was a plan put forward to convert it into houses, and the community rallied around and put forward representations to reject the proposals to convert it in favour of creating a community asset and reinstating the public house. So we started a company. We've sold shares to members of the Odium community, and we have 411 shareholders who are local residents from in and around Odium. Those 411 shareholders have put £250,000 of their own capital into the to the business, and we have been successful in being awarded a grant from the central government department for communities and local government to help us buy, repair and renovate the building and protect the history. The main reasons that we were successful in the grant is that there's a significant recognition within government at a national level and a regional level, and it's represented in the Odium local plan, that pubs play a really significant role in a community in creating a place for people to come together, where groups can integrate and meet, a place where people can celebrate and commemorate and commiserate, and speak to each other and build relationships, and that is a significant and important part of the culture of the country, but also it's a significant and important part of a cohesive community at a local level. So for these reasons, we created the company and have been successfully backed at Hart District level, at the Odium Parish level, and at the national government level in securing funds to save the building and save the pub. A big part of the heritage of the building is not just about the space it creates, but also the views that it has of the church and the stocks and the market square opposite. And a large part of the arguments that we put forward to the planning appeal hearing were associated with maintaining and reinstating those views. So that means giving people the opportunity to sit in the building and outside the building and experience the public open space that's the Bury, and look at the stocks and look at the history and look at the church and soak up that sort of environment, if you like. So what we seek to do here is reinstate the traditions of the past. We've applied for an off licence. Historically, over the past century, the pub has had an off licence, and as you see, with thanks to the representatives on the other side of the table, thanks to submitting the picture back into the evidence pack, is that you see that historically there have been tables outside and people have enjoyed buying a pint in the pub and then sitting in the public open space to make the most of the sunshine, and that's what we're here to seek to do. In terms of the support, we've been overwhelmed by the public support from the people of Odium, and particularly for those in around the High Street and the Bury. The aim of our activity is, in addition to reopening the pub for the heritage reason, the community reason, is to bring additional footfall into Odium to maintain the viability of the High Street and the shops and everything around Odium, so it doesn't become a sleepy commuter town, but actually it's a vibrant place to come and enjoy some time. So as part of the purposes of the organisation that we've set up, which you'll find on Companies House if you choose to look, involves encouraging tourism to Odium and encouraging trade in the High Street by supporting the local businesses. And our intention, working with the council, is to encourage a greater participation in cyclists coming to Odium and walkers coming to Odium and enjoying a pint or a refreshing drink or something after their cycle around the village in that wonderful space that is the Bury. So I'm going to pass now to Michael to talk specifically about the details of the application.
Thank you. Good afternoon. I should just perhaps preface my comments that I'm a resident of Odium for just over 40 years, and so I've known the Bell and its operation throughout that period. It's worth saying right at the start that I have never known the licensing hours for drinking outside the pub to be different than licensing hours inside. Yes, I think unity is the essence of where we're coming from in this. Huge support for what we've done, and wishes that it may long continue. Odium's a very resourceful village, and therefore it didn't surprise me that a wodge of letters was pushed through my door this morning, none of which was solicited, just pushed through. They heard that this hearing was due to take place. Interestingly, 5 of them are from residents in the Bury, saying, please go ahead, good luck. So they're here for you to examine if you wish. As Helen has said, it's always, as far as we can go back, decades for certain. There have been tables and chairs outside, and drinks have been served outside. We have photographic evidence, 5 or 6 pictures here if you wish to see them. I said earlier on, it's quite a resourceful village. What I wasn't expecting to be pushed through my door was a report done without solicitation by a professor of behavioral science specializing in consumer behavior. I wasn't aware of this particular report, but I'm sure you have it at your fingertips. A couple of years ago, there was a report by Cabras, Shakina, and Batterjee on pubs, pints, criminals, and crimes. And it's available for inspection if you wish to see it. But what it pointed out was just the difference between a community type pub and one which is run on purely commercial lines. And the conclusion is that because of its intimate nature, it is highly unlikely that antisocial behavior or public order incidents are likely to occur. Accompanying this was a report from a retired policeman living in the village, and this I wasn't expecting either. But he'd taken the trouble to go back from when records started to investigate whether there had been any reports of disturbance or on police records since May 2013. He examined every month. The answer is none. Moving on. The location of the pub, central to the community of Odiham, is opposite the church. And I've lost count of the number of times when the pub was open that weddings, even funerals, weddings have tipped out of the church straight down to the pub. There's all sorts of reasons why we've got people there who are not resident in the village, why you could have expected some misbehavior or disturbance. Not one. The objections that we've got here, I notice there are 10 names. 6 of those names are married couples. And it's also my belief that some of them are relatively new residents in Odiham and perhaps not aware of the history of the way the bell's been used in the past. To the extent that they'd like to know, please bear in mind that there is simply no records of public misbehaviour reported in the last 13 years. And furthermore, because of the community spirit and the fact that we've got 411 shareholders who we regard as our customers as well as our shareholders, we all have a vested and communal interest in making sure that the pub is run successfully, doesn't upset the neighbours, and that is something which we will continue to maintain. Finally, I would just point out we have a graph here which only came to hand this morning, so I'm sorry I couldn't distribute it. Since we opened on the 10th of February this year, we've plotted the occupancy of the bell and its use. And remarkably, the period is the most activities recorded is 6 o'clock to 7 o'clock. It then tails off slowly downhill towards our closing time. A slight blip at 9 o'clock, but otherwise you can see that most of the activity, and we expect it to continue like this, early evening, 6 o'clock to 7 o'clock. I think that concludes the details I have to submit. So thank you, Chairman.
Thank you. I should just note that while I accepted the comments in the spirit they were intended from the letters and the reports that you referred to, they obviously haven't been submitted as part of the evidence pack that we've got. So I'll take them verbally, but then obviously evidence in front of us. I have one question. As part of the mediation process, there was an offer for no service for consumption outside. In other words, for off sales after 10:15, and external seating to be cleared by customers by 10:30. Now, I know the pavement licence is out of our gift here as a subcommittee, but what are you requesting in terms of timing for off sales? Just for clarification, as per the licence application, or is the 10:15 still on the table?
We are happy to call it at 10 rather than the 10:15. And this also relates to a clarification that we've recently done with licensing over drinking up time. Drinking up time doesn't apply anymore, as I understand. Deborah, is that correct? So we've had to modify our time, but within the overall envelope. So the overall opening time envelope doesn't change, but the hours for serving.
So for off sales, your proposal is 10 o'clock.
Yeah.
Well, I just add to that. So the main timing is like around the sunset. So the usage of the tables outside is really intended for walkers, cyclists, and those members that would come for potentially. We tend to have people come in for a drink after they've been to a club, for example, the bell ringers or the church choir or the hunt or whatever it is that is going on. They do their activity pop in at 9 o'clock for a drink, and typically, as the graph shows, by 10 o'clock they tend to be going home, ready to go to bed for work for the following day. So sunset certainly in June is towards the back end of that 9 to 10 hours. So 10 o'clock would be very appropriate.
Just we had a few times in front of us, so I just wanted clarification. Thank you.
May I add another point relevant to this?
Sure.
We looked at the practicalities of closing service inside behind the bar at 1 hour and the service outside at a different hour earlier. We could see that's surrounded with problems, and probably will generate quite a bit of ill will if we're trying to shut down the outside before the inside. We just feel that 10 o'clock is a fair representation and acceptable to both the inside customers as well as the outside customers.
Okay, thank you.
May I ask?
I was going to I'll just go to the officer first. Do you have any questions or comments, first of all?
Not at this time, Chair.
In which case, I shall come over to respondents.
Thank you. I just wanted.
Sorry.
Sorry, I just wanted to clarify the 10 o'clock time that you're proposing. Is that 10 o'clock and the area to be cleared by 10 o'clock, or 10 o'clock last orders? Cleared by what time, if I may ask?
Could you put the microphones on when you reply, please, sir?
In line with the pub hours, so service half an hour before closure. Yep.
So if closures at
Stop serving at 10.
and if closures at 11.
We would be prepared to accept there's some negotiating room on that. I take your point.
Yeah, I mean, from our point of view, obviously we'll have our turn to speak. But
we're coming to you next. Yes,
it's about noise and getting a cut off. That's all.
Can I just make just one point, and it just covers something that I know you bring up, and understandably so, and that is that there's a request in the representations that we put in measures to control rowdy behaviour and so forth, which we absolutely understand, because it would all fall back on us if it gets out of control. Our method to that is as proposed in the original licence application and the licensing objectives that were agreed back in November. And that is, I have a bit of a thing, and so does our manager, about glass clearance. Sending people round to clear glasses means that we're outside the people, and if there's anything brewing, you have some experience with this, you can stop it before it starts. Once in 12 months, we won't brew it before we start, and then it's up to us to take the appropriate action. But it's under the licensing objectives already that we will cover that by constant clearance of glasses.
We'll be coming to the respondents. Any questions from Councillor Axon or Councillor
Not really a
Drake?
question, just some clarity. I don't know the Bell pub at all. I think you said that before the closure, was presumably COVID, there was an off licence with the pub.
Yes. Till 11.
Until 11 o'clock. So that existed quite
Yeah.
recently.
Yeah,
Okay.
so all of the pubs in Odium, with the exception of the Bell, have off licences until 11. Some of them till significantly later, as custom and practice was with all the pubs in the area. So our licence is already shorter than that, following the previous hearing here, I think, and discussions. But historically, yeah, it's had an off licence until 11.
Thank you.
Thanks.
I have got one, and you've just mentioned the licensing objectives, and that's really great that you've put all of that there. But when it comes to public safety, looking at the area, you've got quite a lot of cars that are parked outside and things like that, and I don't know how much the square is used from a traffic point of view, but that's the one thing that I didn't actually see anything in here.
I take that as well. So the Bury is both a public highway insofar as it's a road. It's also a car park, if you like, insofar as there's parking bays all the way around it that have recently been marked by Hampshire. Odium Council at the moment is in the process of instigating a 20-mile speed limit, which will go through the Bury and also the surrounding roads around it, King Street and Church Street as well. So there is through traffic, but the practicalities of the space, it's pretty confined. So typically people are travelling at maybe 5 miles an hour, 10 if you're lucky, and there will be a speed limit that limits it to 20. In terms of the space itself, the highway, it's not a regular pavement. It's probably 2 or 3 times. I don't know the precise measurements. We can figure that out. It's quite a deep pavement, so there is enough space for tables and still space for a footpath before you then hit the parked cars and then the highway. And certainly
10 feet.
Oh, you've measured it. 3.8 metres. With my hand. Glamorous assistant to my right. And to Michael's point, there haven't, as we've gone through any of the records, been any issues in the past historically with that area.
That's great. That's exactly what I was thinking. How far away is it? And
Yeah.
thank you for that.
Any more questions for the applicants? If not, we can move on to the response. Stuart Bruges.
Hello, thank you very much, and thank you, Deborah, for talking us through these things. So yes, I think I know everybody here already on this side of the table at least. We used to live in Webb House. We've been part of the Odium community for about 17 years, and we used to sing in the choir in the church, and we love the fact that the pub is there and doing what it's doing, and we don't want to we don't want to prevent it from being successful. In fact, we actually bought some shares, a small amount, but we would like to see the success of the pub. But our property is adjacent to the pub. We have a flying freehold over it, so when customers enter. I'm speaking into the microphone so everyone can hear. So when customers enter the pub, they walk through the door, which is below a bedroom, and so we are, in very, very close proximity. So we know we feel it. That said, it has been a pub for years. We know it's been a pub for years. It's always had tables outside, as you say, and I'm not objecting to that. I think it's wonderful to be able to do that, and I'm delighted that most of your activity is at 6 or 7 o'clock in the evening. That's music to our ears, because actually one of the things we're really worried about is the noise late at night when people are trying to get some sleep. So from our point of view, if you could say, it was quiet when people want to get to sleep, we would be a lot more comfortable. So I went to a meeting of the local residents, the immediate residents, in other words, those who actually live adjacent and around the Bury, who are, directly impacted, as opposed to the broader, wider community. And some of the things that came out of that meeting were, well, first of all, just disappointment that they hadn't been involved a little bit, that we hadn't been consulted or brought along on the journey. I know you've done a fantastic job of bringing the wider community and getting shareholders in. You've had very big meetings, and I've been to 1 or 2 of them. But that was some of the feedback from the immediate residents of the Bury, who are concerned about things such as the parking, which I know we're not discussing today, but it is a big deal for people who live in the Bury. It is a busy road that goes through the middle of the Bury, so there is constantly traffic going through that area, because there's a school. There are 2 schools, in fact, and people are always looking for a place to park. And sometimes a day it's extremely difficult to find a place to park, so people do the circuit and do the loop trying to find a place. So some of the concerns from the immediate residents were around traffic and safety, particularly for children. And so if there is room for a proper pavement and proper path so that it can be safe for children, I think that is really, really important. And apart from noise, the other really big concern for us was the smoking, the vaping, and the impact, which again I know is a challenge to manage when it's outside your immediate premises. But we are talking about people drinking and eating immediately adjacent to the pub. So it is essentially an on-premise scenario here. It's not like an off-license where people are taking sales to go and drink back home. We're talking about enabling people to drink and eat on the immediate tables outside. So I think that's very important. I can't overemphasize how much that came up. The comments from residents about smoke going into their gardens and their windows. Another big concern of the immediate residents was the litter, particularly cigarette butts being left round, and just general litter, which has had a big impact and makes a big difference. We have a flower bed immediately outside Webb House, and we were constantly having to remove cigarette butts from that when the pub was previously operating.
Yeah,
so
important. That was under the previous management.
Yeah, previously before. Not under your. So really, we're concerned about things like noise, smoke, litter, antisocial behaviour. We know there has been drinking in the church courtyard. There have been some reported cases where people have vomited in the immediate vicinity. There has been very recently for one of our tenants in Webb House, a fire in their bin. Somebody presumably dropped a cigarette butt in the bin and set fire to it. That's very recent. That was just this weekend, just on Friday. Now we can't know who that came from. We can't say it was necessarily somebody from the pub. But I'm just saying that's something that happened very recently. Really, those are the kinds of things that we would like some controls from the committee about. We don't want to prevent this from happening. We're delighted if it can happen. I think it will be a lovely place to go and have a drink. I hope that there is a way to make it happen properly within some reasonable constraints. And so that people who are working and living in the adjacent windows, and if you see the photographs that we included, you know, we've got bedroom windows immediately outside and above the places where there were tables and chairs previously. So it is impactful, and the cut-off time is really important to us if this is to go ahead and be approved. So that's really where we are, and I think from our point of view, the key point is about what time, not what time the last orders are, but what time is it quiet outside in the Bury. That's what really matters to us. And then, so if I can then introduce my wife Nancy, she's got some more things to say about it.
So just to make it clear that we are here representing a group of neighbours, the neighbours that James met in the meeting the other day. Sadly, I couldn't attend. I was babysitting my own children. And the neighbours, it's fair to say that the neighbours you've got at page 26 of the pack, we're representing them. Lou is here today as well to talk for herself. But there were also a number of others who support what we're doing. Peter and Carolyn Shears, Moira Carey, Yvonne Johnston, John Swat and Dave Osmond. I think they were all too late to get in to be properly represented. But I thought I'd mention that they're also supportive of what we're saying. And what we're saying is we're trying to be as reasonable as possible, because we see the balance that's needed between the needs of the pub, the needs of the community to have a lovely pub, but the public nuisance that will be caused to neighbours if the appropriate conditions are not in place. It's fair to say that although the pub did always have tables and chairs outside, when we lived in Webb House when the pub was trading, it's fair to say the clientele was mostly sort of workmen who would come after work about 4 o'clock, have 2, 3, maybe 4 pints, I don't know, and then drive away in their vans. They would leave relatively early because most of them would be up early again.
I'll skip over that one.
Yeah, I'm naming no names. But that was the kind of general, on an everyday basis, that was the type of use of the pub. And it did the drinking usually finished quite early, unless it was a particularly lovely night, and then people would stay out, late. It's also fair to say that, as far as I know, the pub never had any kind of pavement license. So they never had permission to have those tables and chairs out there. So obviously now they need to do that properly, and we support that. Oh, completely. Yeah, sorry, I should make that clear. This was absolutely nothing to do, this was under the previous landlord. I'm just putting it in context that, pointing back to the way things were done doesn't mean they were done, necessarily in a way that we should emulate today. If I may take you to some of the parts of the bundle that I think assist what we're trying to say, which is really to try and get that balance and get the tailored conditions that will keep everybody happy, and keep this pub as a thriving institution going forward over hopefully many years. I would say, could you look at page 33?
A second. That's the aerial photograph, yes.
That's right. Have you got a colour version of it? Oh, well done. Right. So that's just pointing out, my husband James has labelled this, and it shows, the situation with the Bury. And you can see that the bell is labelled on there. He's stuck in a proposed area for drinking outside, and it's fair to say that's a bit of a guess, and it's probably inaccurate, because at no point have the pub properly delineated the area that they wish to use in a way that that's
Yeah.
clear.
Indeed, nor have we sight of the pavement licence application.
No, exactly. So that's a bit of a guess, and it's but it gives you a general idea as to the area that we're talking about for the off license. And I think it's fair to say the only reason they're applying is not because they just want to give people booze to take out of the premises. They want people to drink on the proposed tables and chairs in that area. And as you can see, Webb House is directly next door. I've also passed forward a picture. I don't know whether you've got sight of that. That one. Yeah, and that gives you a feel of what's there. Directly above the door, the entranceway to the pub, the entrance passageway, is a bedroom of one of our residents. And then there's another bedroom which also faces out onto the Bury, and the windows to the left of that entrance are the drawing room of our residents. So it's all living accommodation. So they're directly impacted by whatever happens in the pub.
Yeah, I just to cut in very quickly, I was told to ignore the bottom half of that photograph because that won't be necessarily where the tables would be located. But
yeah, I mean, and I think we don't have a strong opinion about, exactly where they are. I think that really is for the pavement licence to determine, the exact location of the tables and what's appropriate, taking into account specifically the public safety aspect of children. Sorry, I'm struggling a bit with my microphone. Oh, I can move it. That's wonderful. Aha. Can you hear me all right if I do that? Right. So if the, I think that would be for the pavement licence, the specific location of where the tables will be. And for the record, we want there to be tables. We think it's a good idea. And the other residents who are objecting are dotted about the Bury. So they're all directly impacted by noise, by smoke, and they can speak to those issues. We've got a couple of them here who can talk to you about what they've experienced in recent history. The fact that there may be no police complaints doesn't mean that nothing happens. There are always incidences, and usually neighbours will sort of take it on the chin and just get on with it. But it's important that it's not a completely rosy picture, inevitably, because anywhere where people are drinking, there's always going to be a little bit of argy-bargy. And if I could then take you to page, page 45, please.
there, yes, thank you.
That's the council's own joint statement of licensing policy. And obviously, it seems to me the one that's particularly an issue in this case is the licensing objective of preventing public nuisance. At page 46 over the page, you'll see that at 5.8 at the top, the licensing authority aims to balance the protection of the amenity of the local population with the expectations and ability of local businesses to operate in an environment that is attractive and sustainable for their business. The policy aims to minimise the impacts of licensable activities on residents, visitors, stakeholders and the environment. So that's what we would ask you to do today. At page 46, page 49, I think there's a little bit missing because obviously it's just extracts from the joint statement of policy. And I think it's fair to point out that in the full statement, there is a reference to rural areas and village centres at paragraph 9.2 of the joint statement of policy. And that states that the licensing authorities expect that in general, licensed premises in rural locations will operate earlier terminal hours to reflect the tranquility and lifestyle within the village area and to protect local residents living close to the premises. It is acknowledged that on occasion such premises will wish to extend their hours to support community and other events attended by the village residents. So I'm pointing that out because obviously this is a quintessentially rural location. It's a beautiful heart of the village. It is very different from the high street scenario that has been pointed out by the applicants. They're not comparable. The high street is commercial, full of shops. It's very busy. It's got, you know, it's a different feel. This is set back from the high street. It's much quieter. The applicants describe it as tranquil. And as such, it's appropriate that you did in your application. Yeah. Sorry, I think you did in your application.
In the written application.
Yeah. I can take you to it.
You're misquoting me.
Anyway, we're splitting hairs, but it's a different feel to the high street. It is a rural location, and that's why it's so attractive to be in. At page 51, the policy, the joint policy guidance at paragraph 23.1 talks about tailoring conditions, and I would draw your attention to that, that licenses or certificates are tailored to suit the individual style and characteristics of the premises and its activities and the impact of those activities. And I would say in this situation with such close proximity to residents that it's appropriate to tailor it in a way that gives an earlier cut-off point, particularly for sitting on tables outside. At 23.7 on the same page, it's worth noting that in all cases, conditions will aim to promote the licensing objectives, be unambiguous and enforceable, appropriate to the activities in the business, achievable and applicable to the premises itself and the areas around the premises, which is within the license holder's control. So even though the area that's being talked about is not the premises itself, it is clearly an area around the premises which is within the license holder's control, because if you're actually putting tables and chairs on that land with the specific purpose of selling drinks for people to consume there, I would say that is clearly within your control. If it's not within your control, frankly, it's the Wild West. And then moving on to the statutory guidance, the section 182 guidance at page 57, if I may. Again, this is basically the same point. This is from, if we look at the license conditions at 1.16, and it gives a number of things to take into account when imposing conditions, all of which you'll be familiar with. I would just emphasize the tailored point on the 1, 2, 3, 4, 5th bullet point, but also very importantly, the penultimate bullet point where it states, and I take from the first paragraph, license conditions cannot seek to manage the behaviour of customers once they are beyond the direct management of the license holder and their staff, but may impact on the behaviour of customers in the immediate vicinity of the premises or as they enter or leave. And I would say that anybody drinking at tables that the pub has put out itself would be in the direct management or in the immediate vicinity of the premises, and therefore your powers to condition in relation to such activity are very, very clear and very broad. Moving on to page 61, I just draw your attention to the issues about public nuisance at 2.20, about halfway through, where it says focus on the effect of the licensable activities at the specific premises on persons living and working, including those carry on business in the area around the premises which may be disproportionate and unreasonable. The issues will mainly concern noise nuisance, light pollution, noxious smells, and litter. And at 2.21, about a third of the way through, it may include, in appropriate circumstances, the reduction of the living and working amenity and environment of other persons living and working in the area of the licensed premises. And then there is talk in 2.22 of simple measures. This is about the second line. This might be achieved by a simple, talking about noise nuisance and steps to control it. And they're talking about simple measures such as ensuring doors and windows are kept closed, and that after a particular time, or persons are not permitted in garden areas of the premises after a certain time. And obviously this is not a garden of the premises, but I would say by analogy, it's possible to limit the amount of time that people are allowed to spend in that immediate vicinity of the premises drinking on tables and chairs. And then page 71. This is about the role of responsible authorities. And at 9.12, each responsible authority will be an expert in their respective field, and in some cases it is likely that a particular responsible authority will be the licensing authority's main source of advice in relation to a particular licensing objective. And it gives the example of the police being the licensing authority's main source of advice relating to the promotion of crime and disorder. And I would submit to you that the appropriate that the environmental health officer's advice is to be taken as the main source of advice when dealing with public nuisance. And then if I could take you to that, with the representations at, if I start at page 34, please. So these are the proposed conditions by the neighbours, and they include last orders for drinking by 9 p.m, outside area to be closed by 9:30, and a well-defined area for pub customers, space for pedestrians to pass unimpeded, and that may be something that's more appropriate for the pavement licence. Off-site sales only for customers drinking at the proposed tables. No music, regular monitoring for noise and disruption, which I know that the pub would intend to do anyway, and they've been helpful in their responses in that regard. Signage, I think, again, the pub have come back with some sensible suggestions on that, and they're happy to put signs on the tables themselves. And designation of a suitable smoking area. I think this is a tricky one. The pub have very helpfully said that they will not define any of the tables outside as smoking, which we very much welcome. The question is, where do the smokers go? And obviously, we in the old days, the smokers would go outside our flower bed and puff away, and all the smoke would go into the windows and so on. So I don't know whether there's a way of finding a way of around this. I don't think it's the domain of the pavement license either, to sort that out. As far as I can see, the pavement license rules simply say that you have to have smokers and non-smokers at least 2 meters apart.
Could I seek clarification from the officers on this in terms of what would be covered by a pavement license should it go through? Would that designate where you can or can't smoke?
Does on a pavement license, Chair, but they would not be able to have a pavement license at this premise anyway. And we did state earlier they did submit an application for a pavement license, and it was the wrong application for this because they are very different. Pavement license applications and tables and chairs are they're a different sort of a different type of license, and they have different things stated on them. but each one can have conditions attached. So a pavement license does specify areas for smoking. There are tables and chairs, permit doesn't, but it can be conditioned.
But either way, we're going to have to wait for the new application to see what's requested and therefore what's considered.
Yes, Chair.
And then just going on through the rest of the representations that were made. Outside area to be cleared promptly after last orders. The pub should promptly clear all litter. All of those things I'm sure Roger would have in hand. And the pub should consult its neighbours before applying to vary the licence. I don't know whether you have power to make that condition, but we would be delighted if you could, because we were here before Christmas. We weren't consulted about that, and we haven't been consulted about this in the sense of nobody's knocked on the door or rung us up. We would really love to have proper notice.
Sorry, I can't submit it into evidence, but I do have a WhatsApp chat with Lou offering to meet with you and all your residents at her house at the time of her offering.
Sorry.
Can you contribute?
Yeah, sure.
But also we need microphones in.
Sure.
Shall I just finish my submissions and then we can? Yeah.
Sorry, we are going to come across to others as well, but we have a few questions for you. I have a few questions for yourself.
Yeah, and then obviously such other conditions as you think are appropriate. And then if I could take you very importantly to the environmental health officers' representations at page 29, please. And it's interesting to note that he or she goes further than the residents do. That if I take it from the top, they have no injections, but the proposed external seating area has the potential to undermine the licensing objective of the prevention of public nuisance due to its proximity to residential properties and the increased likelihood of noise arising from customers congregating, particularly during the evening period. Unregulated use of the outside area may result in raised voices, laughter and general patron noise, which by its nature is more difficult to control and likely to cause disturbance to nearby residents. Environmental Health therefore requests that should the application be granted, appropriate conditions are imposed to limit hours of use, control patron noise and ensure effective management of the outside area. And then it's, as I said, it's gone further than we have, in that it's asked that the external seating area shall not be used by patrons after 2100 hours on any day, whereas we asked for it to be cleared by 9:30 p.m. No consumption of alcohol shall take place within the external seating area after 2100 hours. The external seating area shall not be used after the terminal hour for licensable activities. And then it goes on asking for management and supervision, with active supervision, clear and visible notices, no queuing, standing or loitering, vertical drinking shall not be permitted in the external seating area. And noise controls, no live music, no loudspeakers. The licence holder should take reasonable and proactive steps to ensure that noise from patrons using the external seating area does not cause disturbance to residential properties, including preventing shouting, singing or chanting. I'm sure you would, Roger. And then furniture and layout. This may be something that strays into the domain of the pavement or table and chair licence. And then the capacity, 14, the maximum number of patrons permitted to use the external seating area at any one time shall not exceed 16 persons. So quite a sort of robust approach to that. And I think I would say that, bearing in mind what we've heard from one of the directors of the pub this afternoon, that most of their businesses are happening in the early evening. I think it was 6 and 7, he said, and it trails off. I would submit that looking in the round at the serious public nuisance that would be in place if the drinking were allowed to carry on until effectively 10 or 10:30 at night, or perhaps even 11 if the pub was closing at 11, because there was no undertaking by the pub to actually clear those outside tables. Then that, in order to achieve the purpose, the licensing objective of avoiding public nuisance, I would submit that putting in quite robust conditions along the lines of those proposed would be a proportionate and reasonable and balanced approach to the situation. And I actually think it would, from the evidence that the director has given, it wouldn't cause them any harm in terms of their business, or if so, negligible. And it would certainly keep the neighbours very much happier, and hopefully, it would result in a smooth and happy relationship between the neighbours of the Bury and the pub itself. Have you got anything else you want to add? Yeah, so thank you very much, and we're grateful you listening to all my rather long-winded submissions.
Okay, look, thank you very much. I'm conscious that we have someone else who wishes to speak as well, but we covered a lot of ground there. Can I just ask you one question, please? You covered a lot of points. What I don't think I heard was your definitive view, outside of the paperwork at least, or indeed reconsidered view, if that was appropriate, in terms of the stopping of off sales, what you therefore think is an appropriate time. There was obviously a mediation discussion. I've seen what was mentioned, and we've heard 10 o'clock mentioned now. What is your position on that?
I think we stick to our submissions that we put in, which were to a representation, which were 9 o'clock for last off sales, and the outside tables to be cleared by 9:30. That would be our position. That's, we're representing all the neighbours together, and I think that's set against the fact that the environmental health officer actually has more stringent requests. Shows that we're just being reasonable.
Look, I will come to the applicant as well to ask any questions. I'm conscious that you wanted to speak. Are there any further points that you wish to make over and above what's already been said?
Yeah, if it's okay, I'm going to go first because I need to pick up my son in 20 minutes.
Sorry, 1 second. Just as a procedural point, we've come today with the representations that are in the papers. Unfortunately, Carrie Labour's, we don't think we've included that as a relevant representation. So Carrie has said today that she did make one. We have got no knowledge of the content of that because we actually haven't got it. I don't know how it was served, whether it was letter or whether it was email, I don't know. But it's not.
It was an email sent to the original poster that went up in the pub.
Okay.
The email didn't work, so it bounced back to me. So I then sent it to the bounce back email that it said to send it to, and I've had no response from that email.
Okay, so
but I can just talk through my issues aren't any different to what's been raised.
Yeah.
But I do want to speak on behalf of a parent because nobody's really spoke from a parent point of view at the moment, and I'm a parent that lives in the.
This is obviously a public hearing, and we do have to follow process. So I'm just going to take advice, if I may. I want to be as transparent as possible, and you have come along to the hearing, so I will let you make a speech, but I would urge you not to stray too far from the points that have been made, so you could lodge.
That's fine. I want to be as brief as possible. Essentially, I'm a parent who lives in the Bury. So my son is neurodiverse. He has special educational needs. He needs to go to bed and be asleep by 7 p.m. As they've previously mentioned, it's a conservation area. Everything's Grade 2 listed. We have single glazed windows, so you can literally hear everything that happens outside on the Bury. So my main concern in supporting the clearing at 9 o'clock is that my son needs to sleep, and that's all I really wanted to convey. The smoking is another concern for me because my garden literally is onto the Bury. There was a couple of people outside one weekend smoking outside the pub, and it was only 2 people, and I could smell the smoke, and it forced me back into my property because I don't like the smell. And equally, I don't want my son breathing that in. And I think that I would like to speak because, again, they mentioned that it's mostly couples that live in the Bury. That's not the case. I am a young family, and I think it's important that families are represented. Also, another point that was mentioned was
Sorry,
that,
we didn't say that.
yes, you did. You said a lot of couples lived in the Bury.
Okay.
Okay. Have you?
So that's all I want to say. That I think it's important that a family is represented that's got a young child.
Okay. As I said, I've shown a bit of latitude there and allowed you to speak. So, Diane, did you want to speak? You are on the representations list.
I am, yeah. So there's a couple of points I want to raise. Helen very kindly said about, yes, I did go to a shareholders meeting uninvited and did kindly have a chat with her about perhaps it would be a good idea way before here. This is when we were going through all of the renovations, not specifically about this, about the renovations, to perhaps get the Bury people together and actually talk to them about what's going on, what they've got to expect in the future, get them on side up front. The difficulty is...
Sorry.
Yeah, the difficulty is...
Can you speak through me, please? Sorry.
Yeah, sure.
No, let Mrs. finish and I will come to the applicants.
The difficulty, of course, is as a working mum is, it's not my responsibility to get them together. I did try for you at that time when it was just really about the renovation, not as important as licensing. So I'm not saying that didn't happen, but I think from the offset, it's been instigated by us as the residents. I went and spoke to you, wasn't you coming to speak to us? So I think there's been, a lot of goodwill on the resident side. I've got a couple of specific points to raise. Is I have been in the Bury house since the previous landlord and landlady were there, who were incredibly strict on ensuring that any behaviour around the pub was kept on a pretty tight leash. However, we did have, the gentleman raised about talking to a police officer. I actually contacted the police, our community, I've forgotten her name, but the community officer, many times about drinking in the graveyard, which was late at night, abusive language. Down the stable flat, you can see it flanks the graveyard is children's bedrooms. And as Kerry quite well rose, it is single pane glass. There is not a word that is not heard inside these buildings. So that is a concern. It went away. Now, one would answer, and I'm a pretty fair person, one would say, was that related to the pub? I went to see Bob and Sue at the time. They were like, if it is, we're going to clamp down on it. And they did their best to do so. But it was pretty bad, bearing in mind that we did have Alcohol Anonymous meetings in the church at the time. It was pretty much a public nuisance. And moreover, late at night, that's public safety. We are a children enclave. We are a residential enclave. That's the best way I think to describe it. I think the other aspect for me is the parking. Is actually I campaigned like a single warrior for getting the parking much more organised within the Bury, which started with our councillor at the time, Ranul, to get where you can see the car parks where the gentleman said, or the lady, to sit in the bell to see the stocks. You'd never be able to sit in the bell to see the stocks. It's like 2 rows of car park. Yeah. But anyway, I get the romance aspect to it. Is the parking of this area has increased since the pub's got in. So there has been double parking outside. Obviously, somebody in the pub and they park behind it, blocking the highway. You can see outside the Bury house, there's double parking. These are considerations, especially for late night, because the pavement that they're mentioning is, although I'm not against this, I really want the pub to be successful. I'm a real advocate for it. Is the pavement that they want to put tables and chairs on is flanked by a residential building, a grade 1 listed wall. In fact, it's a wall in its own right. And it's the only pavement for children. So we've got church and 2 schools and 1 pavement of which we're going to have drinking people on.
Okay.
And I think that's my points, Chair.
Okay, no, thank you very much. Okay, I'll make the point that we've made before. The pavement licence, unfortunately, it's not for the consideration of the subcommittee.
Dark on which one we're coming to talk about. It's not very clear. We're not going for a licence. So by all means, include us at the right time, because I believe you've got to put a yellow board in the Helen. By all means, if you can reach out at that time, I will do my utmost to support for you to mediate directly with the Bury.
Okay. I've got to be balanced here. I mean, I do, whether there's a lot of emotion clearly on this topic, but
it's just the facts.
Yeah,
we've lived through this before. It's not true to say that they're all new residents. We're not.
Okay. I mean, I get the sense, I do get the sense from listening that there has been engagement with the community on this. And I did ask at the start if the statutory obligations have been met for the conditions, and I was told that they were. So I think the licence application would have been public and clear. And I think there's been a degree of talk. But anyway, that aside, I'll move to the applicant now. Do you have any questions or points that you want to make in terms of what the respondents have said?
Just a very quick one. We did make the statutory representations for the pavement licence application. It was posted in the pub window next to the off-sales licence application. So both were advertised and advertised in Hampshire, whatever it is that we have to do.
I think all I would urge is, my point is, Helen, you've got contact with the people in the Bury. There's 8 houses. It's not difficult to knock on 8 people's doors. Yeah, we're not talking about 80. Yeah, so I think that's what I would urge to be perhaps a better way of mediating.
And the point is that.
Just to, yes, likewise stating here, a pavement way is 3.8 metres wide from the building. Post tables that we have proposed in the pavement licence application, notwithstanding it's separate, are 1.65. So there's 2 point whatever it is left pavement. If the
we can talk about that at the relevant, I'm happy for you to have feedback from, yeah.
Anything else?
Yeah.
Response to the respondents or questions?
There's just
questions to respondents.
A couple of things. The first one was just back to the business plan for the business. So we're a community-run organisation. We have deliberately priced our operation to be at sort of the lowest price point we could possibly achieve in order to make it maximum accessible to the community. And that business case stacks up based on maximising the tourism that comes to Odium, maximising the engagement from the community groups, and an intrinsic part of that was around use of the courtyard and use of the tables and reinstating the tables that had previously been for the pub. And in terms of consultation on that, we've done probably 10 different public consultations about the business plan that includes that as the logic. Both in the church and at the Cross Barn, that have been advertised on the notice boards in Odium, have been advertised on Facebook, and have been advertised to every resident in the parish via the parish newsletter through the council, including mail drops. So since 2022, we have been engaging in a consultation with all affected individuals in the vicinity around this proposal to run a business for the community, run it by the community, and run it for the benefit of the community, where any profits that are earned are then reinvested in sustaining the heritage asset. So any money we make, we use to fix the Grade 2 building and keep it for future generations. Just in terms of the 9 o'clock thing, Michael was right in terms of the graphs. That the trade that we experience is people come in at the end of their working shifts, maybe from 4 till 6, and they enjoy a drink. Then they typically go away and eat. somewhere else. And then often there's another sort of surge at 9 and then it drops off. During the summer months, and we haven't got to summer yet, so our data doesn't show it, historically, organisations would finish their activity at 9 o'clock and come to us or come to the Bell for a drink after their activities. And we see that with various different groups at the moment. You have the 2 or 3 choirs. We've got the Heart Male Voice Choir, the Church Choir, the Jubilee Choir, the Bell Ringers. There are different groups and activities that finish at 9 and then come to us for a drink. And particularly they're looking forward to, and we've had a large number of customers saying, when are you going to get tables back? When are you going to get tables back? Because sitting outside the Bell as the sun goes down and in that warm space is a very pleasant thing to do. The concern with a 9 o'clock cut-off is that it means that we lose all of that trade, that we'll just go to the high street or to the cricket club or to other places. And once those organisations get out of the habit of coming to us, the financial viability of the whole business starts to diminish. And then once it goes, we won't be able to go back round this. If we can't make this business work this time round, that's it, it's gone. 500 years of pub over.
Thank you. Further points very quickly, and in terms of what the respondents said. We'll get to summing up in a second.
Yes, just to remind the assembled congregation here that I do have 5 letters written by people who either live in or attached to the Bury or wishing us well.
You made that point, but
and secondly, this outside area, to the extent that we will use it, it is part of making our business work. It's quite important for us to have it. We don't want to exceed any hours that we're selling inside the building. It is an important part of our profitability.
Okay, thank you. 1 second. If that's the questions, I will come to the lead officer first, just to unless you have any further questions for the respondents.
Any questions, Chair?
Okay. In which case, and are there any further comments to make on the environmental health representation, or should we take it as submitted?
Yeah, I mean, I think it is complex, obviously, because there are 2 application types, and in the environmental health officer's submission, there are clearly a lot of measures that are raised which are going to be relevant to the tables and chairs license application.
I accept that, yes.
Yeah, and there's some relevance to it, and there is also a license condition that's on the existing license about noise management checks as well, which you obviously will take into consideration.
Yeah. The one thing I don't recall seeing was that I think the timing is obviously a point of contention. I take those points. The other one that was mentioned was the vertical drinking outside, or lack thereof, I think, in the environmental health submission. In other words, drinking only sat at tables rather than stood around.
Vertical drinking.
Yeah, anyway, that's fine. I have some questions from here anyway.
I mean, which is the point which the chair has made here with regard to vertical drinking. I hate conditions or being put on applications which are not really enforceable. They look good, but how is that actually? I mean, are you expecting people to go out and say, sorry, sir, sit down, there's no seats here? You know, it makes it unpleasant. So I find conditions like that unreasonable in my thinking in terms of application. Good idea. Don't disagree with it. But actually applying it. And the other one was patrons are not expected to queue or stand. So I find those sort of things hard to interpret in terms of a practical way. What did you have in mind? People can't stand outside and queue to go into the pub, or?
I'm not the environment health officer, so I'm here from licensing. But it is what you think is appropriate and practical and enforceable to put on the license with what you find is appropriate in view of the evidence. So that's fine if that's, you're absolutely right, because they do need to be plainly worded. They need to be workable. We endorse that. You can take into account the matters that have been raised, and then you need to determine what is appropriate to add to that license.
I accept that with us. Yes, absolutely.
mentioned about accessibility to everyone. And I also noticed that because of the age of the building, obviously it's quote some areas uneven floors and things like that. Would this outside space, would that accommodate more for people with disabilities and things like that to access the pub?
Yeah, absolutely. Thank you for the question. So we've submitted a planning application, separate planning application, to convert one of our small outbuilding cupboards into a disabled accessible toilet lavatory, and that has been approved. We're just in the process of raising the funds to actually execute it. It isn't practical for wheelchair users to use a majority of the inside of the building. It's just physically not possible to navigate. But our intention and part of the business plan and as on the Companies House website, making the pub accessible to a majority of users regardless of their needs is really important to us, and the outdoor space is absolutely key to that. So yeah, absolutely, this would suit that need.
Okay, we've heard a lot of evidence on all sides and some questions, and thank you very much for sticking with us and answering them. I will now move to the summing up, and I will start with the lead officer, if I may.
Thank you, Chair. Applications must be considered on their own merits, with activities, conditions required to be tailored to the application. The subcommittee must focus on today's hearing on the proposed variation, the steps considered appropriate to promote the licence and objectives that have given rise to the representations received, and avoid straying into undisputed areas. We have full appreciation for that all that has been stated regarding the conditions for tables and chairs already. And without prejudice, Chair, the subcommittee cannot condition outside the premises plan. I know we've already stated this. That will be for the tables and chairs permit application. I mean, some conditions can be put on, but not with regards to the seating.
We will take appropriate advice on that should we need to.
It is particularly important that the reasons should address the extent to which the decision has been made with regard to the Council's statement of licensing policy and the Section 182 guidance. Should members make a decision in departure of these documents, the decision notice must document reasons for that departure. The subcommittee must determine today's hearing within 5 working days, and when determined, the licensing authority must issue a decision notice including the reasons for the decision. Thank you.
Okay, I'm going to go to the applicant and then the respondent. We've had fairly lengthy submissions from all sides, so I would ask you to keep your summary as brief as possible while making the points you want to make. Over to the applicant. Is there anything further you just want to add by way of summary?
I'd like to endorse Councillor Axham's comment. Some of the requests that have been raised are just impractical to police, and will make life quite difficult for us trying to run a happy and community-centred pub, telling people to sit down when they should be, if they're standing up, closing the hours that we can serve drinks outside before we serve them inside. Just think about the reality of running a pub. And I'd also ask people to think about, there's a pub there, it's been there for over 500 years. What do you expect? Of course, if you really can't stand life around a pub, don't live there.
And then summary, Mr. Stewart Bruges.
Yes, I think for us, the main point remains is that there are people very close proximity who need to be able to get up the next morning to go to work, and get some rest, and some of them are children, and so I just respectfully ask that you consider those people. Say something.
No, that sums it up. Thank you.
Okay, we've heard a lot of evidence on all sides. It's clearly not straightforward, and there's a lot of documentation, a lot of feeling. So we would like to take our time over it. Therefore, we won't ask you to hang around to wait for us to come back with a brief statement. What we will do, though, is we will issue a formal written decision, and that has to be issued within 5 working days. So we won't ask you to hang around today, but we will issue that written decision in the required timeframe. Is that okay? Yeah. In which case, I think we can declare this subcommittee hearing closed.
Thank you for the opportunity.